After Congress eliminated the tax on certain NFA items, many gun owners celebrated, and many assumed that if the tax disappeared, the NFA might not survive for much longer. But now the federal government is fighting back. In a major new court filing, the DOJ has revealed exactly how it plans to keep the NFA alive, and its arguments could affect every major challenge that's currently working through the court system. According to the DOJ, the NFA has never really been about the tax. According to the government, the NFA was never solely about the tax stamp, and if the federal courts agree, the fight over suppressors, SBRs, short-barreled shotguns, and AOWs is far from over. So let's break down exactly what the DOJ is now arguing in this latest filing and what this means for the future of the NFA. Now, before we jump into this video, if you like this type of content and you want to make sure you get it going forward, make sure to subscribe to the channel and also turn on all notifications to never miss these videos when I release them. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're backed by an actual law firm, the Attorneys for Freedom, and they're always trying to expand upon their benefits to give you as much as possible as a member. And right now, until the end of this month, if you sign up using my exclusive code ARMSCHOLAR, you can get $50 off of your individual sign-up fee or $25 off the family fee. So if you're interested, you can find them using the links down below in the details section, also in the pinned comment. Now, as I mentioned in the intro, in this video, we're going to be discussing another major NFA challenge that is trying to build off the recent $0 tax changes. This case was filed in the Eastern District of Kentucky by a coalition of gun owners, firearms businesses, and two-way organizations that are challenging the NFA's remaining restrictions on suppressors, SBRs, SBSs, and AOWs. We've already discussed the major challenges filed by Silencer Shop, the Brown case, and the Jensen case, and now Roberts has also joined the growing list of challenges against the NFA. Now, the basic argument from the challengers in this case is very straightforward. For decades, the federal government justified the NFA primarily as a tax statute. In fact, the Supreme Court upheld the NFA in cases because it was tied to Congress's taxing powers. But now that Congress has reduced many of those taxes to $0, the plaintiffs argue that the constitutional foundation supporting those restrictions has largely disappeared. And according to the challengers, if there is no meaningful tax left to collect, well, then there is no reason for the registration requirements, the approval requirements, the transfer restrictions, and also the criminal penalties that remain in place. But now the government has responded with its final reply brief before this court actually rules on the summary judgment motion. So here are the key arguments that the DOJ is now making to try to save the NFA, and they really revealed their main defenses for why they want to keep the NFA alive. The DOJ is making four major arguments for why the NFA is still valid despite the $0 tax change, and also why this case should be thrown out. First, the DOJ tries to narrow this battlefield before even touching on the merits of the case. The government is asking the court to outright dismiss one of the organizational plaintiffs, which is American Suppressor Association Foundation, or ASAF. The DOJ claims that ASAF is violating the procedural rule against claim splitting because its sister entity, ASA, is already suing over the exact same NFA regulations in a separate lawsuit in the state of Missouri. So, essentially the DOJ here is trying to prune away as much of the case as possible before the judge addresses the constitutional question that has actually been raised in this case. So they're trying to use a procedural maneuver to dismiss one of the plaintiffs in some of these arguments. Second, the government says that the NFA is still supported by Congress's taxing powers. The DOJ points out that while Congress reduced the making and transfer taxes on suppressors, SBRs, SBSs, and AOWs to $0, it did not eliminate every NFA tax. Importers, manufacturers, and dealers of NFA firearms still pay a special occupational tax. According to the federal government, the registration and approval requirements help to enforce and collect that remaining special occupational tax. So in other words, the DOJ argues that because some NFA taxes still exist, Congress still has authority to maintain the broader regulatory framework and keep it in place. But that's only the beginning of their arguments. The government's third argument may be even more important and also is an issue that's currently at question and is being disputed currently in the Fifth Circuit. The DOJ argues that even if the taxing power were insufficient, Congress can regulate suppressors and SBRs through the Commerce Clause. According to this brief, suppressors, SBRs, and dealers, manufacturers, distributors, and purchasers all participate in a national interstate firearms market. Because those items move through interstate commerce, the federal government argues that Congress can regulate them regardless of what happens to the tax stamp. So this is an extremely important argument because it signals that the government is preparing for a future where courts may become skeptical of relying solely on the taxing power. If the taxing argument weakens, the DOJ wants the Commerce Clause available as backup justification for the NFA's current structure. And if courts accept that theory, it could dramatically change how future NFA challenges are actually litigated. But like I mentioned, currently right now, the Fifth Circuit is reviewing this whole Commerce Clause question surrounding federal gun control laws. And they're following a direct call from Justice Thomas in the Hamani decision saying that he wants lower courts to revisit this Commerce Clause question. So even though they're leaning on this additional argument surrounding the Commerce Clause, even that may come into question very soon. Now, the fourth and final DOJ argument against this challenge revolves around the Second Amendment. This Roberts case isn't just about congressional power. The plaintiffs are also making a direct Second Amendment challenge. And here the government relies heavily on historical arguments that we've seen in other NFA cases, but they also walk out the new arguments that the NFA is simply a shall issue licensing system similar to what happened in the Bruin CCW case. The DOJ argues that SBRs and SBSs have historically been treated differently because they are concealable and allegedly associated with criminal misuse. And the DOJ then argues that under Bruin and recent precedent by the Fifth Circuit in the Peterson case, the NFA is simply a shall issue licensing scheme similar to CCW licenses. In their brief, the DOJ argues that plaintiffs principally contend that the NFA is not a licensing regime at all, but merely a registration regime. But that's the wrong way to look at it, according to the DOJ. In its basic design, the NFA requires that any individual who seeks to lawfully manufacture, make, transfer, receive, or possess an NFA firearm first must obtain the government's permission, or one could say, according to the DOJ, they have to get a license to do so. So the DOJ continues to want courts to extend Bruin's dicta on shall issue CCW permits to now the NFA and how it operates. Now, what makes this Roberts case so important isn't necessarily the plaintiff's arguments. We've seen many of these arguments before in other cases. What makes Roberts important now is that we now have the federal government's complete blueprint for how they plan to defend the NFA post-tax stamps and reductions, and that blueprint will likely show up in every major NFA lawsuit now moving forward. The federal government has now officially told the courts even if the transfer tax is gone, the NFA survives because of the taxing powers, the Commerce Clause, the Necessary and Proper Clause, historical firearms regulations, and also they believe this does not violate the Second Amendment because it operates like a shall issue permit. Whether courts ultimately accept those arguments remains yet to be seen, but this filing gives us perhaps the clearest picture yet right now of how the government plans to defend the NFA after the $0 tax change. So that's the latest update in this NFA challenge, Roberts versus the ATF. This is one of the many cases right now moving against the NFA, trying to use the $0 tax changes. And this case is now being submitted to that federal court in Kentucky, and they're arguing that this court here should strike down the NFA because of the $0 tax change. And right now, this is being submitted to that court on a motion for summary judgment. So really soon, we will get additional information on how this case is proceeding. So as this case develops and as other NFA challenges move forward, I will let you guys know. If you guys like this type of video and this type of content and you want to make sure you get it going forward, make sure you like, comment, subscribe, and also turn on all notifications to never miss these videos when I release them. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.